Good day, everybody, and welcome to that legal capsule about fuel price adjustment clause, one contract at a time. And I'm with my colleague, Sarah, who will start with the first part about that topic.
Hi, everyone. So we will start by talking about the basic principles of municipal contracting. Afterwards, we will cover the basics so you can understand how to draft a fuel price adjustment clause. We will also provide tips to facilitate their enforcement. We will discuss their usefulness and share pitfalls to avoid. Finally, Stéphane will provide an overview of the legal framework that applies to ongoing contracts. So firstly, what are the basic principles of municipal contracting? Municipal tendering is governed by the Cities and Towns Act and the Municipal Code of Quebec. Above the threshold determined by the minister, municipalities are required to go to public tender. To do so, they must use the Government of Quebec Electronic Tendering System, the SEAO, and invite contractors to submit their tender via this platform. The courts recognize that municipalities are bound by the tender documents they prepare. Once they award a contract, all terms and conditions must be respected by both the municipality and the tenderers. This also includes any clause regarding the modification of the contracts and the mechanism to amend such a contract. If the tender documents do not allow a modification of the contract, it cannot be added afterwards. Stéphane will talk about that in a few minutes. Municipalities must also ensure that they comply with the principles and standards of their contract management bylaws. Beyond those bylaws, they have an obligation to ensure equality among the tenderers by treating them fairly and by allowing them to submit their tenders on the same basis of information and following the same rules. As such, the court recognized that when municipality or contracts, they are agreeing to uphold the rules set out in their tender documents. Successful tenderers also agree to follow those same rules and to execute a contract according to the price they submitted in their tender, even if the circumstances change. Based on those principles, you can now understand that if the tender documents do not include an escalator clause, which is also known as an escalation clause, tenderers cannot submit tenders that contain such a clause without risking being rejected for non-conformity. On the other hand, successful tenders cannot claim an unforeseen situation and ask to add a price escalation clause after the contract has been awarded. In fact, doing so is right now considered illegal. But given the current fuel price situation, how can a municipality make its offer more attractive? Is the inclusion of an escalator clause a good idea? What is the usefulness and what are the benefits of an escalator clause? The extraordinary circumstances of the past few years have caused many prices to fluctuate, making the evaluation of fuel costs for tenders a daunting task for even the most experienced contractors. This proves to be a challenge in contracts for services that directly involve vehicles, such as waste collections or snow removal. This type of clause allows all parties to share the risk of a fuel price increase or decrease in a way that reflects market conditions. It is important to note that both the municipality and the contractor can benefit from such a clause, whether it's an increase or a decrease of the fuel price. That said, escalator clauses are not a cure-all, and you must be careful during its redaction. Their terms and conditions need to be analyzed carefully, and there are some pitfalls you should avoid.
Thank you, Sarah. Effectively, can be beneficial for both parties to have such clause, but a poorly drafted clause can be a source of headaches, frustration, dispute, and ultimately cost more money to the municipality. When drafting an adjustment clause, you must be aware and pay particular attention to the following. First, the reference price. Secondly, the frequency at which variations will be measured. And finally, the benchmark that you will use to adjust the price. The municipality must indicate in its tender documents how it intends to calculate the adjustment, for example, on a monthly basis, and how often it will be adjusted means a greater transparency. So the tenderers will know exactly what they are going to sign if the contract is awarded to them. For example, if a contract is awarded for 6 years, the municipality could state into the tender documents that the reference price is that price, and that it will be, for example, readjusted monthly using the average price of the previous month. Municipality also have to establish how the benchmark are set in order to determine whether there is an adjustment for a period or not. Some municipality may choose to refer to documents prepared by impartial third party, which can be easier for them because the third party will calculate the variation. However, you have to make sure that if you use such a document, the document is available for the tenderers in the process. So it is available and clear for all that you refer to that specific document. Contracts awarded after a tendering process are adhesion contracts, which means that in case of disagreement between you and the contractor, you will have to prove that the contractor was aware of the document you were referring to during the tendering process, and that document was clear and was available for all. Otherwise, it can be considered invalid. Furthermore, by referring to external documents, you are at the mercy of any change that may occur to those documents while the contract is going on. Even those documents can be no longer available after 1 or 2 years of the contract. So you have to keep in mind that it can be a good idea, but for this reason, we find it better, or we recommend that you incorporate escalator clause right into the tender documents. There is no reason to restrain from looking at examples from external sources. But if you do so, you simply need to cite the reference that you're using to establish the benchmark, as well as the price change index for comparison purposes. But the first question you must ask yourself is that kind of clause a good idea? Well, it's not a yes or no answer. It depends on the particular circumstances of your municipality, especially the budgetary constraint, the reality of the market in your area and for that particular service. You must stay aware of the financial implication, for example, of a fuel escalator clause that will go on for the next 5 years, where the price of the fuel can vary greatly. Then for that period, the risk of fluctuating prices may impact your budget. And you have to keep in mind that, the budget can go over what was planned. For that reason, you may find it a good idea to put a price cap to limit the adjustment clause so that the municipality will not go too far over budget. But where can we find the inspiration for drafting clauses that will protect municipalities' interest while remaining attractive to tenderers? There are many examples that you may find inspiration in, but the MAMH suggests that municipality refer to the MTQ clauses, which are available online. Be careful, though, to refer to a specific standard and not just to the MTQ clause, which means nothing. So refer to a specific standard and check with your legal advisor, which will review the clause to make sure that it's legal and clear and that there are no potential enforcement issues once the contract will be awarded. As Sarah said before, those points do not apply to ongoing contracts because ongoing contracts, which do not include escalator clauses, cannot be modified during the contract. Neither can they be modified between the opening of the tenders and the award of the contract. Because tenderers who add escalator clauses to their tenders may have those tenders rejected as they would become conditional, and this is not allowed. The law established that adding fuel price escalator clauses to ongoing contract is against the stability of the equity between tenderers, and it's not legal. Moreover, the courts confirmed that the doctrine of frustration in contract, which is a doctrine of common law, which permits in certain circumstances to modify awarded contracts, is not valid in Quebec jurisdiction. Neither is the force majeure, which cannot be invoked during the execution of a contract to say that, well, we're facing higher prices during the execution, so we must adjust them. The force majeure is not a principle that must be invoked or may be invoked in that case, even if the price increase is based on extraordinary circumstances as a war or pandemic situation. However, each case is unique and municipality must act in good faith and in the public best interest. So it is possible in specific cases that the lesser evil will be to negotiate something with the contractor rather than to have to deal with a bankrupt contractor. In case of doubt, please consult your legal advisor, which will help you make all the adjustment and suggest specific solutions to your individual situations.
We thank you for listening to this legal capsule, and we hope that it answered a few of your questions regarding price adjustment clause.